ઓફ ઇન્ડિયાએ કરી છે, જો ફિનાન્શિયલ ક્રેડિટર અગેન્સ્ટ ધી ઈડી. આ એપ્લિકેશન છે ઈડી અને એઝ વેલ એઝ પાર્ટી બનાવ્યા છે જે કંપની લિક્વિડેશનમાં આવી છે, અને અમારા એક બોરોવર જે ક્લિક ટેલિકોમ છે. ક્લિક ટેલિકોમની સામે કઈ લિક્વિડેશન નથી એટલે એમને જ પાર્ટી બન્યા છે. અને સાહેબ આમાં નું એપ્લિકેશન છે ફોર રિસ્ટોરેશન જે પ્રોપર્ટીઝ કન્ફર્મ્ડ છે ફોર અટેચમેન્ટ. ઓરિજિનલ અટેચમેન્ટ ઓર્ડર હતો એ ફર્ધર કન્ફર્મ થયો, એની સામે અમે લોકોએ રિસ્ટોરેશન કરી છે. અત્યારે જે મેઇન એપ્લિકેશન આપણી છે કન્ફર્મ થઈ ગઈ છે. અપીલેટમાં સર અપીલ ચાલતી હતી એ તો ખારીજ થઈ ગઈ છે, બટ એમાં અમને છૂટ આપી છે કે અમે લોકો અહીંયા એપ્લિકેશન કરી શકીએ ફોર રિસ્ટોરેશન. અપીલ એસબીઆઈ કરી હતી અટેચમેન્ટના ઓર્ડરની સામે, એ રદ થઈ ગઈ છે. ધેટ ઇઝ રિજેક્ટેડ, ધેટ ઇઝ ડિસમિસ્ડ. બટ while dismissing on merits, તમે છેલ્લું પેજ વાંચશો તો એમાં છૂટ આપી છે કે એપ્રોપ્રિએટ એપ્લિકેશન while this special case is going on before this honorable court, અમે લોકો રિસ્ટોરેશન માટે તો જરૂર અરજી કરી શકીએ. એટલે કન્સોર્ટિયમ છે સાહેબ. એટલે અમે કરીએ કે ઇન્ડિયન બેન્કર બધા સર 5 થી 7 બેંકોનું એક કન્સોર્ટિયમ છે. અલગ અલગ બેંક્સ અપીલો લઈને ગઈ હતી, જોઈન્ટ અપીલ બધી ડિસમિસ થઈ છે. કન્ફર્મેશન ઓર્ડર ઉપર કઈ નથી, અમે જીતી શક્યા, બટ અમને છૂટ મળી છે કે એટેટમાં તો અમે તમારી પાસે આવી શકીએ. ધેટ ઇઝ ઇન ધી લાસ્ટ 2 પેજીસમાં છૂટ અપાયેલી છે. જ્યારે અમે સર રિજોઇન્ડર ફાઇલ કરીને આ એપ્લિકેશન કરી ત્યારે ઓલરેડી અપીલ ચાલતી હતી, હવે ડિસમિસ થઈ ગઈ છે બટ છૂટ આપીને, એટલે આજની તારીખે આપણે આમાં ફર્ધર જઈ શકીએ છીએ. ધેટ ઇઝ માય હમ્બલ સબમિશન ફર્સ્ટ. હવે સર એઝ અ બેંક અમારો એક લેજિટિમેટ ક્લેમ છે, કેમ કે જેવી રિસ્પોન્ડન્ટ છે ઈડી સિવાયના એ કંપનીઝને અમે સાહેબ 2012 થી લોન આપી છે, અને ત્યારબાદ અમારી પાસે એના મોર્ગેજ બી છે. હા, એનું સર તમે પેજ વાંચો તો સાહેબ પેજ નંબર 19 મારી સીઆરએમ નો પેજ નંબર 19 માં એક એનેક્સર આપેલું છે કન્ફર્મ પ્રોપર્ટીઝ. સાહેબ એ બધી પ્રોપર્ટીઝ કન્ફર્મ અટેચ છે, બટ એના અમારી પાસે બધા મોર્ગેજના ડોક્યુમેન્ટ્સ છે, એટલે અમારી પાસે એક સિક્યોર્ડ ક્રેડિટરનો હક છે એ બધી પ્રોપર્ટીઝમાં તમામ 19, 20, 21 પેજ નંબરે તમને ટોટલ 32 પ્રોપર્ટીનું લિસ્ટ છે. એ બધા
સ્ટેજમાં ઈ પર્ટિક્યુલર ભૂષણ પાવરમાં ચાર્જીસ ફ્રેમ થઈ ગયા ને પછી અમે હા પાડીએ છીએ. જી સાહેબ. બટ સાહેબ તો પછી આઈબીસી વિલ પ્રિવેલ, એટલીસ્ટ અમે ઈ જોઈ શકીએ. આઈબીસી માં તો સાહેબ લિક્વિડેટર સાહેબ ગયા છે, દેટ ઇઝ અ સેપરેટ. અહીંયા અમારો એક અમે હક ઓલરેડી તમને જે ઓર્ડર દીધો છે, અમને પીએમએલ અપીલેટ એમ કે છે કે તમારી પાસે આવીએ, કેમ કે યુ હેવ અ પ્રોપર જ્યુરિસ્ડિક્શન, તો અમે તમારી પાસે આવ્યા. હવે સાહેબ એમ થશે કે ચાર્જીસ ફ્રેમ પછી આવતો, ચાર્જીસ ફ્રેમ સાહેબ આ 2019 ની મેટર છે. બટ સાહેબ મેં એવિડન્સીસ જે દીધા તમને, સુપ્રીમ કોર્ટના ઓર્ડર છે, પીએમએલએ સ્પેશિયલ કોર્ટ દિલ્હી છે. બટ સાહેબ તો ઓર્ડરમાં કોર્ટ લખે, એટલીસ્ટ ઈડી ધ્યાન દોરે સાહેબ આમાં છે ને ચાર્જીસ ફ્રેમ નથી થયા. ઈ ક્યાં ઓર્ડરમાં ના પ્રેસ રિલીઝમાં ઉલ્લેખ થાય છે, ના સુપ્રીમ કોર્ટમાં જ્યારે આટલી મોટી એફિડેવિટ થઈ ગઈ કે તમે રિસ્ટોર કરી દો, ત્યારે બી કોઈ સ્ટેજનો ઉલ્લેખ ન થતો. દેટ ઇઝ મીન્સ કે ઇટ ઇઝ નોટ મેન્ડેટરી ઇન માય હમ્બલ સબમિશન. સુપ્રીમ કોર્ટમાં જે એવા આનાથી વધારેની અટેચમેન્ટની રિસ્ટોરેશન મળી ગયું છે, અત્યારે ઈડી બી આપી રહી છે સાહેબ કે નો ઓબ્જેક્શન, તો પછી સાહેબ મે કાઇન્ડલી કન્સિડર એકોર્ડિંગલી. આઈ વિલ રેસ્ટ માય કેસ ધેર યોર લોર્ડશિપ.
friend में my learned friend is appearing for Click Telecom, and is arguing for the properties which are there in the liquidation for Sign, Sujot, and Atrium. So this is not permissible. That's my first submission. My second submission is that today Click Telecom have no locus standi at all to raise any objection for those properties which are not even owned, or they don't have any interest. They don't have any interest, right, title or interest for those property which pertains to those three companies. Now he is arguing the case on behalf of those properties. Now, as far as the subject matter before NCLT is concerned, they are pertaining to those properties for the companies which are there in the liquidation, more particularly Sign, Sujot, and Atrium, which has no access apparently as far as interest is concerned. So as far as locus is concerned, they don't have any locus standi. As far as the separation part is concerned, today liquidator is duty bound to carry out the process in view of the IBC. And every quarter, I'm supposed to report to the Honorable National Company Law Tribunal that this is the progress which has been done. And in accordance with those provisions, this application has been filed by liquidator. That's my first submission. And in that application also, which is there on page 24, no relief has been prayed for against the Click Telecom. It's entirely a different scope. And even otherwise, there are judgments to that effect that both these proceedings can go simultaneously. One is under IBC, one is under PMLA. They are not contradictory to each other. Those proceedings are. My third submission would be, as far as Rule 3A is concerned, my learned friend has stated that in view of Rule 3A, when charge is not framed, no application shall lie for restoration of properties under Section 8.8. But this is something unheard of, because the language of Section 8.8 as far as Rule 3A doesn't prohibit any applicant or person who is having legitimate interest. They are not deprived from preferring any such application. Otherwise, the language would be no application would lie. That is not the language. As far as Rule 3A is concerned, I will make a brief submission for assistance of my lords, but this is one of the judgment which is required to be looked into. Am I with my notes?
So let them give a copy to me as well.
I'm
Judgment की
I'm
copy नहीं
I'm
आपका
going to
साहब.
give them the entire
After
submission which I have
arguments-
been made right now also.
साहब after
All,
arguments.
all these judgments along with the compilation I can
साहब,
supply
साहब,
them.
after arguments में आप सो बना judgments.
हाँ,
क्या हाँ? So how will I revert?
I will
Or-
give
or
them
some day
entire
will be
written
given for revision.
submission, whatever I have
But
argued
साहब
today.
judgment cite करे मैंने judgment वांचवा ना दे तो how will I revert on those judgments?
અને એક અને બે એના ડાયરેક્ટર હજી કોઈ? આરોપી નંબર 3 અને 4 કંપની છે અને એક અને બે એમના ડાયરેક્ટર્સ છે અને એ લોકો કંપનીનું બધું કામકાજ સંભાળતા હતા. કેમ્બ્રોક ઇન્ડસ્ટ્રીઝ અને તેની બીજી અન્ય ગ્રુપ કંપનીએ ભેગા મળી અને આઈસીઆઈસીઆઈ બેંક અને અલ્હાબાદ બેંકમાં ખોટા દસ્તાવેજો બનાવી અને દસ્તાવેજોના આધારે ક્રેડિટ ફેસિલિટી અને લોન મેળવી અને આઈસીઆઈસીઆઈ બેંકમાંથી 126 કરોડ અને અલ્હાબાદ બેંકમાંથી આશરે 444 કરોડ રૂપિયા મેળવી અને પરત નહીં કરી ડિફોલ્ટ કરેલ છે. આ રૂપિયાનો આરોપી નંબર 1 અને 2 નાઓએ પર્સનલ ખાતામાં એકાઉન્ટમાં ટ્રાન્સફર કરી રૂપિયા 15.5 કરોડ પર્સનલ એકાઉન્ટમાં ટ્રાન્સફર કર્યા અને અન્ય પ્રોપર્ટીઓ એમણે ખરીદી અને રોકાણ કર્યું અલગ અલગ જગ્યાએ અને સર્ક્યુલર ટ્રાન્ઝેક્શનથી દૂર કરી અને દુરુપયોગ કર્યો છે. ઈડી દ્વારા પ્રોપર્ટી અટેચ કરી છે. એનો ટ્રિબ્યુનલ દ્વારા કન્ફર્મ થયો છે. ઓર્ડર 30/11/2022 ના રોજ ઓર્ડર કન્ફર્મ થયો છે અને આ અંગે શેડ્યુલ ઓફેન્સ નો ગુનો નોંધાયા પછી ઈડીએ તપાસ કરી અને આપ નામદાર કોર્ટમાં ફરિયાદ ફાઇલ કરેલ છે. આ સાથે દસ્તાવેજી પુરાવા અને સાક્ષીઓના નિવેદન લીધેલ છે. 39 સર વિટનેસ છે, 51 ડોક્યુમેન્ટ છે અને 3525 પ્રૂફ છે સર અને જેથી ચાર્જ ફ્રેમ કરવા માટે આરોપીઓ સામે પૂરતો પુરાવો છે.
Yes, sir. Purpose. My lords may kindly see this judgment. This was delivered in 2012 by the High Court. And as far as the paragraph 9 is concerned, page 9, I'm sorry. Page 9. Here, one of the aspect has been discussed, and pursuant to that, my lords will be troubled to look into the section 88 and rule 3A.
Yes.
Page
Indian-
9, page 9, point number 2.
Indian Bank.
આ જજમેન્ટ છે શાસ્ત્રી ભવન પલદીપ ઇન્ચી સોફ્ટવેર. This is just like been hand over.
Indian Bank ni?
Huh?
Judgment of Indian Bank?
Yeah, Union Bank. Indian.
Title. We are referring to which judgment?
Only this. This is Indian Bank only, Indian Bank versus Government of India.
Yes.
Page number 9.
Yeah.
Paragraph number 22.
Era number?
22.
Oh.
The second question that arises for consideration is as to where would be the claim of the bank stand if the property is taken to present for the proceeds of crime. I think this question is to be extreme importance for various reasons. Therefore, it requires in-depth analysis. This is, I just want to point out that what is the legislative object and intent as far as Rule 3 and 8 is concerned. It can be easily appreciated from the narration of the fact that the very initiation of the action by the respondent is on the basis of criminal complaint lodged by the three nationalized bank with the Central Bureau of Investigation. Today, the respondent presumed that the allegations are true. The respondents have proceeded with the action in terms of Prevention of Money Laundering Act only in the presumption that the allegations made by the banks in their complaints are true. Now, if presume that the allegation made by the banks in their complaints are true, then these nationalized banks are the victims of fraud committed by the company and its officer. In other words, it is the bank's money which has actually been made use by the company and its director to buy properties in their names. Where do these victims stand vice accused in such cases? Unfortunately, the Prevention of Money Laundering Act 2002 doesn't appear to take note of the above question wise as to whether the victim stands. Interestingly, a look at the paragraph 1 of part B of the schedule shows that the offense of kidnapping, ransom punishment under section 364A of the offense related to extortion of punishable under section so and so, and offense relating to robbery and dacoity punishable under section so and so have also been made schedule offense. If the value of the property involved is more than 3 lakhs, therefore, the properties which represent the proceeds of a crime can be attached under section 5 of the act, and adjudication can take place in terms of section 8. On order of attachment is confirmed and adjudication and accused is convicted, the property gets confiscated in terms of section 8(6) of the property and confiscated 8(6) and vested absolutely in central government, free from all encumbrances. Now, the next paragraph. In other words, Prevention of Money Laundering Act not only seeks to punish the offenders, but also seeks to punish the victim of such offenses. Now, take for instance case where an offense of kidnapping or ransom punishment under section so and so takes place. If the amount involved is more than 30 lakhs, it is schedule offense under the special enactment. Therefore, if the accused is apprehended that the charge under this act and the money is also recovered, then the person who paid the ransom money to the accused and who happens to be the victim of the crime will lose the money by virtue of section 8(6) and section 9. Now, he would therefore prefer in turn hostile in criminal case by reaching an agreement with the accused so that the attachment order gets lifted under section 8(5), enabling him to take away his money. Now, this is a very dangerous situation that in absence of such provision, the person who is informant himself is constrained to turn hostile. So this was the situation prior to this enactment. And the same analogy holds even for offense of robbery and dacoity punishable under section so and so, which are included in paragraph number so and so, schedule property to the central government virtue of Act 8(6) and section 9 of the act. If stands taken, the respondent is accepted for the victim of crime, there would be virtually to be different between accused of this and central government, as in case there would be to loss to their property to either of the two. Coming to the facts of the case, it is very clear from the facts of the case that the respondent have proceeded that if the order of adjudication made by the adjudicating authority becomes final after the conviction of the company and it's directed by criminal court, the central government would confiscate such property in terms of section 8(6). Thereafter, the property would vest in the central government fee.
You can say what is the conclusion?
Please, my lord. Now, the conclusion is that the earlier, before these enactment of section 8(8) or rule 3A came into place, there was situation where the victim or the informant, they were only sufferer. And to fulfill this lacuna, this is an inherent lacuna in the statute itself. The section 8(8) has been enacted. If my lords may kindly see the section 8(8), which clearly says that where a property stand confiscated to central government under subsection 5 of the Special Act in such manner as may be prescribed, may also direct central government to restore the confiscated property or property thereof claimant with legitimate interest in the property, who may have suffered a quantifiable loss as a result of offense of money laundering, provided that the special court should not consider such claim unless it is satisfied the claim has acted in good faith and has suffered the loss despite having taken reasonable precaution. So only 4 cardinal principles are required to be looked into while exercising the powers under section 8(8), and that is when legitimate interest, suffered quantifiable loss, has acted in good faith and taken reasonable precaution, and they are not involved in the offense of money laundering. Provided further that the special court may, if it thinks fit, consider the claim of the claimant for the purpose of restoration of such property during trial of the case in such manner as may be. Here the discretionary power are given to the court. that during the pendency of trial, the trial court may order for restoration of the property. Now, this discretionary power cannot be curtailed by any procedure or rules. And if my lords will look into the procedural aspect, Rule 3A, it doesn't say that it is a mandatory provision. If it is a mandatory provision, the legislature would have carved in a different manner, which is completely absent from bare perusal of section or Rule 3A. If I may be permitted to read only.
It does not even say that it is directory.
I must tell my lord said why it is directory and not mandatory. Because if it is mandatory, it would contain that no claimant shall be entitled, which has been there in Rule 3A, sub-rule 3. No claimant shall be entitled to claim restoration of the property referred in sub-rule 1 before special court beyond 30 days from the date of publication. Likewise, there is another proviso that no restoration of property shall be passed by a special court under these rules without giving an opportunity of being heard to the owner of the property. So these are the mandatory provision. Whereas in first two lines, the special court, after framing of the charge under section 4 of the Act, on the basis of an application moved for restoration of the property attached under subsection 1 of section 5 or seized or frozen under section 17 or 18, if confiscated, if it thinks fit. So here completely discretion has been given to the court, and that discretion is required to be exercised in light of three cardinal principles which has been enumerated in section 8.8.
After framing of charge.
That is 8.8, and that is that legitimate interest which is there in the section 8.8.
You are qualifying, but then there is another criteria also that after framing of charges.
After framing, that is only directory by respect to submission. My lords may take a view that it is not a mandatory, it is directory, or it is not directory, it is mandatory. But the cardinal principle, because a person who himself is involved in the offense of money laundering, that no possession should be restored in favor of such a person who is involved in offense of money laundering. That is the object of incorporating Rule 3A. In this particular scenario, neither liquidator nor banks, they are the accused of money laundering. They are
Your
not
application before the NCLT. You applied before the NCLT.
NCLT for those three companies which are in liquidation.
So there you did not get any favor.
There it is still pending.
It is pending.
It is still pending.
And there he was referring that for some order has been passed that is challenged by you.
That is the order of attachment.
How?
It has been challenged before the tribunal.
Tribunal. You have challenged that order.
That it has been challenged by the bank.
liquidator service bank has not gone bank PMLA માં ગયું તો આ લોકો એન્ક્લેટ માં ગયા એટલે PMLA માં ખારીજ થઈ ગયો ઓર્ડર મેં તમને આપ્યો
આ PMLA માં તો છે.
હા પછી અમે એન્ક્લેટ કે NCLT માં સાઈડ નથી લિક્વિડેટર સાઈડ.
And here the Click Telecom company, which is raising objection, their property is not even part of these application also.
We, for a moment, we will keep them aside. Also.
Please, my lords.
And also, what about the procedures?
Procedure is that this is a separate procedure in IBC. That the possession of the assets is required to be taken over by the liquidator. Because in view of the provisions.
If property is taken by you, then you act accordingly. Property is taken up by the liquidator. Under which powers?
Under 35, under 33, under 32A, it is the duty of the liquidator to take.
Then you go ahead with that procedure.
But there I'm facing a different challenge of jurisdiction. There are judgments to that effect, and there are views also to that effect that it is required to be entertained by a special court. And as far as the property of which are there in the liquidation, I am only concerned with those property. Those wider properties where banks are also having claim, there I cannot do anything. That's the difficulty. And if my lords will kindly see the very legislative object of IBC. The legislative object of IBC is.
IBC you deal with. Why I should go for IBC?
Because there can't be any such provision like Rule 3A or 8.8 which completely diminish the
It is
object.
there in statute book. Rule 3A is there in statute book.
Please.
But there might be some reason.
There
Now,
is reason.
my power are concerned, it is under PMLA only.
Please, ma'am, and
I would not go for IBC.
please, ma'am. And probably the reason why rule 3 is that the accused person who is involved in the offense of money laundering, no restoration of possession should be granted in their favor. And probably for that purpose, the rules have been incorporated that after framing of charge, that once charge is framed, it is endorsed that these people are not involved in the money laundering. So in my respectful submission, my lords can always exercise
My
discretion.
powers are under section 8.
8 and which are
So I will
discretion in nature. And my lords can always exercise those discretionary
I-
power.
So far as PMLA concerned, there might be different statute would be overlapping each other. But while exercising my power as a special judge, I will be bound by the PMLA only.
I am grateful.
And therefore, we'll have to satisfy that why rule 3A can be bypassed. Both of you can.
No, I am not saying that it should be bypassed.
No, bypass in the sense, a rule 3A procedure should not be followed and it can be straightway given over to the bank or to you. Yes.
There, my lords may kindly see on the.
Because before this
I-
court, anyone would be
I
coming.
come- I come-
Either accused would be coming,
I
to
come.
restore my property.
I-
Accused may also come.
I come.
Some third party would come to the court. Yes,
No, this is also a judgment.
you have supplied this copy.
Oh, no, I have already supplied to you. That's it.
Yes, yes,
Oh,
I have.
I'm so sorry.
I
Yes,
have.
please, my lord. Paragraph 8 on page 4.
Hmm.
Respondent number 3 has objected the application by filing reply. According to it, property in dispute is liable to be confiscated on conviction of the accused in view of section 8(5) of the
I
Act.
would simply go through it. But it would not be the even pursuancy value also not for this order. This is the order passed by the special court.
Please, ma'am.
So even if it is the decision of other high court, it could have persuasive value.
I'm just assisting my lord
Because you are
for
assisting.
assisting us also
I
because
got it.
today
But this, I can't rely upon this.
I completely but as far as there
You
are
can point out any high court judgment which can be I can refer it.
there is not a single high court judgment which says that in view of rule 3A, the trial court or special court cannot exercise power for restoration of property. In
There
fact,
can be negative.
there are
No,
judgments where instead
See,
of
there are judgments. If it is not there, then till date it is not. We don't know. Tomorrow it might come. Your legislative intent is very much clear. I agree by everything. I agree by the IBC also. It might be having the overriding effect over the PML also. It would prevail, not overriding effect. Though both are having same provisions. But there is decision. Okay, now in view of this, IBC would prevail over PML. But so far as I am concerned, my jurisdiction would be confined under the PML only. I can go for IBP or Company Act provision. I would be governed by the money laundering only. So now if you can satisfy that rule 3 would not be required in this case, you can point out any such decision.
I come.
Either of you or you.
There is only one submission.
Not submission, it should be supported by some case law.
Case law written in the reply today filed by ED, page 8, your lordship. That is the special case court's order. There in page 9, they have discussed while restoring that there is no strict rule to follow. The trial has to be commenced to.
Which is the
consider
judgment? Which is the judgment?
Judgment. The competent authority of Krantivira Samboli Rayana Urban Cooperative Society versus Directorate of Enforcement in special case number 89 of 2002.
89 of
2022. Here, your lordship, it is in the decision it is coming, which they have said that there is
by
no
which high
strict-
court? By which high court?
Special court, PMLA special court.
That he has already given one judgment. But I can't be.
Your lordship, our high court at one end is safely saying, જ્યારે IBC અને PMLA નું કોઈ બી jurisdiction who
There is, I
parallel
would say you there is direct decision of the Supreme Court also. Okay, IBC would be having priority over other cases.
Sir, if I may. Sir, Delhi High Court has taken a view that IBC is not going to prevail over the PMLA Act. There is a direct judgment of Delhi High Court on this. That judgment is standing before the Supreme Court and the issue is pending before the Supreme Court till date. The judgment which my learned friend is referring of Gujarat High Court. So that was a different case because in IBC there is a provision which says, which is section 32. Section 32A says once the property is sold, once it is sold, then all attachments will go. The section 32A of IBC only applies once the property is sold either in liquidation or in resolution process. If it is sold, then all attachments will go. That is what 32A says. But keeping that section aside, whether IBC will prevail over PMLA, but there is a direct judgment of NCLAT, Delhi High Court, every court has taken a view, no, IBC is not going to prevail over the PMLA Act. Because IBC.
But there are judgments.
Sir, I can cite, I can. bring to-
ગુજરાત હાઈકોર્ટ કહી રહ્યું છે
Sir, ma'am.
પછી તો
Sir, exactly, ma'am. ये गुजरात हाई कोर्ट की जजमेंट है ये not decide करती कि IBC will prevail over PMLA. What Gujarat High Court judgment says is कि there is section 32A in IBC Act which says कि once the property is sold in liquidation or in resolution, then the attachments will go. But that section only applies in cases when once it is sold. So what will happen in a case prior to the selling of the property? So there, all courts have taken a view, Delhi High Court, NCLAT, everyone has taken a view, so I can bring those judgments. But that may not be necessary for this court to go in. But everyone has said it is no, IBC is not going to prevail over PMLA. The reason being is PMLA applies on proceeds of crimes, whereas IBC applies on debt. That is why.
You are right. But then, the basic, we forget every law. We forget it.
We don't have to go into this.
There is one property
Yes,
which is kept either as a mortgage
yes, yes,
or some surety,
yes.
and the borrower borrows money on
Yes.
that basis.
Yes.
Now he occur loss in his business or he run away with that money.
Yes.
Now what is available is that property.
Is a property.
So the borrower can't take that benefit of overlapping jurisdiction.
I understand.
There cannot be any provision of the act which would be benefited for the wrongdoers. There can't be any provisions.
But the provision.
Maybe it might be overlapping jurisdiction. The borrower might make every attempt for reasons known to him. But
I understand.
there can be, it would give license to that wrongdoer against these legitimate claimants.
So the provision only.
Now suppose कि for sake of argument, EDS 7, let it go to, we don't want to.
Yes.
Then the circumstances changes. Because now ED is saying that our purpose is that we collect the proceed of crime, whether it is from A, B, C, whoever. Most of it is banks. And now they release their property, okay, let it go to the bank, let it go to the liquidation. Then whether can borrower say, no, now it is proceed of crime, so it should be dealt as proceed of crime. The bank already has got some order against you.
I'm not saying bank has no.
So in that circumstances, there are also principles, the procedural aspect can't defeat the very intent or some legitimate claim.
Sir, here, sir, our argument.
You might be right, because there is rule 3A.
Sir,
But then that rule 3A cannot be interpreted or read as it would defeat. It is procedural. There is a procedure prescribed. It is with the PMLA Act. The rules are prescribed, okay, this is to be done in this way. But when there are more than one jurisdiction for the very same, then that aspect is to be considered. Coupled with the fact, ED now says, yes, we don't want to let it go. Liquidator is also saying, yes, let it go to the bank. Ultimately, it is going to me. I would be dividing this money to the. So, in this context, your locus in the sense,
sir, they have.
Your say.
It was a mistake on their end to join me as a party, but they have joined me today as a party.
no. Then you are once again benefited. They are there to benefit you. First, it was your borrower. Now they are benefiting you. You can work out on this issue. In these circumstances, there might be case law. It would not be the first unique case.
Probably there are cases, but where without discussing.
Because earlier when ED has objected, that application is rejected by my predecessor. That is rejected, but they were objecting at that point of time. Now
Please.
this circumstances have been changed.
Please.
I believe there will be some judgment for 2019 onwards.
And I don't think you are saying that there is decision PMLA would, that IBC wouldn't prevail upon PMLA. You cite those reasons, but I,
So may not have to go. I'll cite those.
no, even I will also work on that. But so far as ACG is concerned, Special Economic Zone, Delhi, it is a Noida case where Supreme Court has said that IBC would prevail on this ACG Act. It is Noida, it is cited and it is by Justice Oka. And there is even one judgment of either of Bombay High Court or Madhya Pradesh High Court, wherein they have stated that IBC would prevail over PMLA. But maybe you might be also right in saying when property is sold away or not sold away, and then that applicability.
Then it changes. Before that, Delhi High Court even.
So once this is the status of the property, one would apply. If that one step has gone ahead, or
Yes, sir.
then it might not apply. That would be.
Gujarat High Court को A judgment A से એના કારણે attachment should go because
આ બેક ટુ ડિફર યોર લોર્ડશિપ કેમ કે એમાં સ્ટ્રિક્ટલી લખેલું છે તો પ્રોટેક્શન ગ્રાન્ટેડ અંડર 33 સબસેક્શન 5 and 33 સબસેક્શન 8 સબસેક્શન 2 of IBC would override the power of.
But these are you are right, but I am telling કે I am.
32 ની વાત છે 32 ની વાત જ નથી સર હું ખાલી એટલું જ કહેવા માંગુ છું કે હાઈકોર્ટે 32 my learned friend is right, but while passing order in 32 capital A, High Court has also stated that 33 એનું જ્યારે હોય ત્યારે બી કેવી રીતના જોવું just
That
while
is-
on liquidation also the attachment is wrong. That is a
You all of
difference.
the issue Supreme Court.
That is a minute difference here.
Sir, A other issue not just it is beneficial for me because our issue is pending before Supreme Court.
But your lordship-
Every issue under PMLA, IBC, that are always pending before the higher courts.
But as far as
This is the reason that
I should decide, I should, મારા હિસાબથી relevant જ નથી કે IBC કેવી કરશે કે PMLA. My argument is a general law માં કે એ separation છે બીજું એમ્પ્લાયમાં proceedings pending છે same. અને બીજું તો
operation not on his part. See, he has not gone there.
But sir, I've been those documents ultimately, sir.
I will deal with the argument, but on that aspect, I wouldn't be.
Sir, generally to what, once company goes into liquidation, sir.
આમાં એવું છે ભાઈ, દેશી વાત આ બધું સોફિસ્ટિકેટેડ હોય ને, કોર્પોરેટ એટલે દાભાણી સાહેબ,
હાજી સાહેબ.
હા, આપની જે MSCP દાખલ કરી છે 536/2025.
હા, ઇકબાલભાઈ સિપાઈ.
હા, ઇકબાલભાઈ હુસેનભાઈ સિપાઈ એ છે, હાજર છે એમના તરફે કોઈ?
સાહેબ એ બીમાર છે એટલે આવી શકે એમ નથી. કાલે કીધું તો આવવાનું, પણ અંતર વિસનગર બાજુ છે એટલે ને મોબાઈલ થી કોઈ કોન્ટેક્ટ થાય એમ નથી.
હવે એમને જે ઈજા થઈ છે એમાં થાપાની ફ્રેક્ચરની ઇન્જરી છે.
હાજી.
હવે તમે જે દાખલ કરી છે 3 લાખ રૂપિયા માટે કરી છે,
હા.
અને તમારી જે ગણતરી આવી છે એમાં 2.5 લાખ માટે સમાધાન માટે તૈયાર છો એવું કહે છે.
હાજી સાહેબ.
હા, હવે ICICI તરફે કોણ હાજર છે?
જી સર, દેવ પટેલ ICICI તરફે હું હાજર છું સર.
શું આપનું નામ શું કહ્યું?
સર દેવ પટેલ,
દેવ પટેલ.
લીગલ મેનેજર.
ઓકે. હવે એમને 3 લાખના ક્લેમની સામે 2.5 લાખ રૂપિયા કે છે. આપની કંપની તરફે શું છે રજૂઆત?
સર અમારી ઓફર 2,10,000 ની હતી.
પણ ફ્રેક્ચરની ઇન્જરી છે
હા સાહેબ.
અને
જી
થાપાનું
સર.
ફ્રેક્ચર છે.
ફીમર
હા.
ફીમર ફ્રેક્ચર.
હવે ઉંમર 70 વર્ષ છે એટલે મલ્ટીપ્લાયર તો 5 નો જ આવશે.
જી
હાજી સાહેબ.
હવે રહી થોડોક જે ડિફરન્સ રહે છે એમાં આવકનો ડિફરન્સ છે.
yes.
અને મેડિકલ બિલ્સ કેટલા છે?
69,000. 69,000.
950.
ઓકે. એમાં તો તમને વીમા કંપની એમાં કોઈ ડિસ્પ્યુટ નથી ને?
નો સર,
Medical bill.
એમાં કોઈ ડિસ્પ્યુટ નથી.
પેઇન શોક સફરિંગમાં 15,000.
જી સર.
હા, ઓકે. એમાં વાંધો નથી ને બંનેને?
ના સર, જી.
પછી બીજા એડ હેઠળ 12,000 આપીએ તો?
જી સર, કોઈ વાંધો નહીં એમાં.
તો હવે જે ખાલી ડિફરન્સ રહે છે એ મંથલી ઇન્કમમાં રહે છે બંને વચ્ચે.
ડિસેબિલિટી.
આ ડિસેબિલિટી અને મંથલી ઇન્કમ.
હાજી સર.
ઓકે. કેટલી ઇન્કમ? 1700 ગણે છે.
આમ તો સાહેબ મે રિક્વેસ્ટ સર,
જી જી.
આમ તો સાહેબ આપણે નવા કાયદા આપણે જે અહીંયા મીટિંગ થઈ હતી છેલ્લે ત્યારે 2025માં 11,000 ઇન્કમ ગણવાનું નક્કી કરી યુએસસી
જી.
કંપની છે.
હમ.
અત્યારે મેં 10,000 કીધા છે કે હવે યાર ડિસ્પોઝલ બે થાય જલ્દી.
એટલે એમને 10,000 તમારે 10,000 ઇન્કમ ગણીએ વાંધો નથી ને? કેમ કે નવા પ્રમાણે હવે ઇન્સ્યોરન્સ કંપનીમાં
નો સર, નથી.
તો હવે ડિસેબિલિટી પૂરતું છે, એમાં કંઈક થોડુંક ઓછું કરો આપણે ડાભાણી સાહેબ. 21% ડિસેબિલિટી ગણી છે.
સાહેબ 1-2% ઓછું કરે આપનું માન રાખવું. હિપ જોઈન્ટ પાસેનું ફ્રેક્ચર છે ફીમરનું. આપકો એટલે સાહેબ મારે માનવું પડે ને.
ના હું બેયનું હરખું થાય એવું કરીશ.
હા,
પણ મોટો ડિફરન્સ નથી રહેતો. તમે બેને 2.5 કયો છો તમે અને પેલા 2 ને 10 કહે છે. બેની વચ્ચેનો ફિગર કહી દઉં હું.
હા કહો સાહેબ.
જી સર.
2.10 અને 2.50 વચ્ચે 2.30 થાય ટોટલ.
માન રાખીશ સાહેબ.
માન રાખશો? યસ. તમારે ઇન્સ્યોરન્સ કંપની?
જી સર, ટ્રિબ્યુનલ જે સર સજેસ્ટ કરશે તો એ આપણે
એટલે
એગ્રી છે.
2.30 બંનેને કબૂલ હોય તો ફાઇનલ કરી નાખો.
હા
જી સર,
ફાઇનલ છે.
ફાઇન.
ઓકે.
જી સાહેબ.
બરાબર. તો હું એ રીતે ગણતરી કરીને કેલ્ક્યુલેટ કરીને 2 ને 30
પછી જી
જી સર.
આપનો ખૂબ ખૂબ આભાર સાહેબ.
ના, તમારો બી આભાર કે આટલું જલ્દી એમએસસીપી પૂરી કરો છો.
સાહેબ અમે
Thank
તો
you,
રેડી
sir.
જોઈએ.
આપણો
અમે તો
જાન્યુઆરી 25ની એમએસસીપી એપ્રિલ 25માં પૂરી થાય તો સારું જ કહેવાય ને?
સાહેબ
બંને
આપના
અને
સાથ
સર મેટર જે છે સર 9 તારીખ જ ફાઇલ થઈ છે, એટલે આપણે એવા ગણવા જઈએ તો 15 દિવસ જ થયા.
આ તો સૌથી સારું કહેવાય ને.
જી સર.
એટલે
જી સાહેબ.
તમે બંને તૈયાર હો તો 3 મહિના 5 મહિનામાં તો ફેટલ ડિસાઇડ થઈ જશે.
રાઈટ સર.
જી સાહેબ.
અને પેલા ઇન્જર્ડ પર્સન ને બી 70 વર્ષના ઉંમરના છે, એમને બી
જલ્દી
તરત
પૈસા ભેગો.
ઓકે. ચાલો, હું ઈચ્છીશ કે હવે જેમાં આ 9 તારીખે દાખલ થઈને આજે પૂરી થઈ છે, તો આવીને આવી હવે બધા જ કેસોમાં આઈસીઆઈસી લોમ્બાર્ડ અને દાભાણી સાહેબ બંને મહિનો ઇન્જરીના કેસમાં અને 3 મહિના ફેટલના કેસમાં સમાધાનથી પૂરી કરી નાખે.
જી સાહેબ.
જી સર.
ચાલો, બંનેને અભિનંદન ને થેન્ક યુ. 2:30 કરું છું ફાઇનલ.
જી
જી
સાહેબ
સર.
આપનો
2:30.
આપનો ખૂબ ખૂબ આભાર.
હા. અને શનિવારમાં લઈ લો. ત્રીજી તારીખમાં લઈ લો. આ પેલા શનિવાર વાળામાં લઈ લઈશું પરમેનન્ટ લોક અદાલતમાં.
જી